Terrific. I had the pleasure of living in Prague for 3 years, have since been in New York now for 6, but I'm always very pleased to have the opportunity to come back here. Although I will not try to pepper my remarks with Czech, as I don't think I advanced much in my language capabilities here. The issue of costs is a frustrating issue, I think, for both parties at this stage, because the standards by which tribunals decide whether to award costs or how to treat the issue of costs is not set out. And what we really have is multiple approaches by tribunals and decisions that involve millions of dollars where the tribunals have not actually set out a lot of reasons. So when the state has spent millions of dollars from the public purse to defend itself in a vigorous and strong way, the question is, should the state be able to recover those expenses? And then if they are the prevailing party, and then if the claimant does not pay the award, what should it do about it? And should it go and enforce that award? Essentially, the treatment of costs has two approaches. One is what's now known as the American rule, which is that each party pays its own costs. And that is the tradition in the United States, where the fees for filing claims is very low, the threshold for bringing litigation is very low, and then instead of having any penalty for bringing a case unless it's really frivolous, each party is responsible for its own fees and costs. The opposite approach is known as CFE, costs follow the event, or phrased much more colloquially, the loser pays. Now, in commercial arbitration, regardless of who the parties have been, international arbitration tribunals have traditionally followed the cost followed the event, loser pays approach. But in investment treaty arbitration, the approach has been quite different. And historically, tribunals have preferred to allocate costs equally and required the parties to bear their own costs. What we've seen is there's been departure of this approach when there's been egregious behavior by one of the parties, described as dilatory tactics or overtly spurious claims, misconduct, or abusive process. But more recently, the trend has shifted, and the question is, are we now at a point where we're no longer saying that investment treaty tribunals follow the American rule and are looking more toward following the loser pays approach? The question for the representatives of governments here and those who are representing governments in cases is it better for governments to have a loser pay approach, knowing that if they lose, then they also have to pay? But what we've seen is, as the trend has changed and tribunals are awarding fees and costs, they are more likely at this stage to award a claimant their fees and costs than they are a state. So if we're going to have this approach, it shouldn't be just for a claimant. And that's something that state representatives really need to articulate and be vocal about. So what happened historically is there were 4 key reasons articulated by tribunals as to why they applied the American approach or said that each party should bear its own costs, even when one party was the clear winner and the other party was the clear loser. One factor was essentially that these arbitration claims under bilateral investment treaties were considered novel and new, and so a losing party shouldn't be penalized for that. Secondly, if a claimant presented a case in a clear and efficient manner, then there was a feeling that, well, the claimant lost, but they did it efficiently and therefore shouldn't be penalized. Another factor was essentially that those who are responsible for the potentially bad behavior by a party would not be the one impacted by an award of fees and costs. And therefore, the tribunal felt that that award would not be the right message sent to the right bad actors. But all this really boils down to basic idea that parties should not be denied avenues of justice, and that if somehow the thresholds for filing claims and the penalties for filing claims is too high, then that could be a real risk. And essentially articulating an idea that, well, the state may have to pay significant sums to defend itself. Those expenses are essentially a cost of access to justice and due process. I would submit that those traditional reasons have really been eliminated now, particularly as Matthew was articulating earlier this morning with third-party funding and lawyers essentially chasing investors to bring claims and say that they will bring them on contingency basis. So the case Thunderbird versus Mexico in 2006 is really that threshold case that noted the historical approach and said that we are going to reject that position and adopt the cost follows the event approach, except when the investor, when the issues of access to justice are really at play. Albert Jan Vandenberg was the chair, and I think it is something to note that if, as we're talking about who to appoint in a case, looking at arbitrators who have experience in government, as was discussed earlier this morning, looking at arbitrators who have issued decisions that are favorable to states, and also looking at arbitrators who have issued decisions favorable to states with regard to costs. Now, in that decision, the late Thomas Wald issued a very strong dissent and essentially said that this Thunderbird decision is a, in his words, significant departure from established jurisprudence. Now, the Plama versus Bulgaria case in 2008 is another case that's regularly cited for an award of costs for a state. And Carl Salland was the president. Albert von Janderberg was on the tribunal, as was Johnny Wieder. Now, that claim was brought under the Energy Charter Treaty and concerned the privatization of an oil refinery. There was a bankruptcy, and the claimant looked to blame the state. And ultimately, the tribunal said that the claimant took a high-risk project without having the financial assets and to carry that out, and for reasons which, in the tribunal's opinion, are not attributable to unlawful conduct by the state. The plan did not work, and the company failed financially. So you had a clear win for the state. And so the question was, should costs be awarded to the state? The claimants submitted their costs, and that was $4.7 million. The respondents' costs were $13.2 million. So ultimately the question was, well, if costs are going to be awarded, are they going to be awarded in full? And the tribunal split the baby, and with the last name Salomon, I am very interested in this whole concept of splitting the baby. And essentially the tribunal said the claimant should bear $7 million of the respondent's fees plus all of the fees and costs of the tribunal, because they considered that amount to be reasonable. So again, from a state's perspective, if you're thinking about making your cost submission, it's the question of what is ultimately the reasonable cost, and we are seeing tribunals look at that in relation to the claimant. Now I want to now turn my attention to our two victories for the Czech Republic in the last couple of years, because In both of those cases, the tribunal did award fees and costs to the state. The first one is brought by a claimant, Napolski. It was under the Czech-German bilateral investment treaty, and ultimately the case was concerning water rights and whether the state had somehow done something to impact the claimant's rights and access to water in the Czech Republic. Now, it was very, very clear from the get-go that this was obviously an individual claimant, but not a very sophisticated claimant, and not a claimant with a lot of resources. The claimant also was a dual citizen, and so under the Czech-German bilateral investment treaty, the issue was where was the claimant's dominant residence. So one of the tactics we took, knowing that even if we were successful, and even if we got an award of costs, what can and you try to enforce it, is that truly a victory for the Czech Republic? So let's try to do everything we can on the front end. So one of the tactics we took was ask the tribunal for a very steep advance on costs. So that, again, this meant that both parties, including the state, would have to pay this significant money up front. But it essentially put the claimant to the test. You know, do you have the money, and are you serious? And from a tribunal's perspective, they also don't want to be caught short and not having the claimant pay. So they adopted that approach. And the second was we pounded the claimant with just document requests and bifurcated the case in connection with jurisdictional phase to really look at the claimant's dominant question of where was his dominant residence. Then the claimant wrote to the tribunal and said that because of his, quote, serious economic problems related to financing of this arbitration, which means he's not able to pay the requested advance, he asked to discontinue the proceedings. So ultimately, from the Czech Republic's perspective, that's a win. So the Czech Republic's not going to object to a discontinuation of the proceedings, that's for sure. But we said there should be a discontinuation of the proceedings, but there should be an award of the Czech Republic's fees and costs. Ultimately, from a public perspective, the Czech Republic, or any state, should not be put to the burden of defending itself in a case where, let's see, the claimant tries to see if it can get a significant settlement or just see what happens kind of as a folly. And so, and in this case, ultimately the question is, well, should they have to bear the burden of defending manifestly unsound claims? So the tribunal in that case actually went through an analysis and said that the Czech Republic was fully in its right to prepare its defense and that its costs are justified. And in fact, it said, and this is important, it is a state's duty to ensure that its case will be put forward in such a way as to preserve its good repute, especially with a view to fostering future investments. And I know that has really been the Ministry of Finance's approach in defending itself in these cases, which is to send a strong message that it's going to defend itself in a sophisticated way. The tribunal then said, that being said, of course, there's always a however, it is necessary also to consider the other party's situation, noting that the claimant is in financial difficulties and took steps to withdraw his claim. So the tribunal explained that the strict application of the cost follow the event principle goes almost uncontested in international commercial arbitration, but not in investment treaty arbitration. And that goes to the concerns about access of justice and ultimately what are the risks of the liabilities for the claimant if they bring unsuccessful cases. So the tribunal basically said that the issue is not whether the respondent was excessive in the preparation of its defense and concluded expressly that it was not, but that ultimately they have to balance the issue with these denial of justice questions and access to justice and concerns about the financial capability of the claimant. So in this regard, the tribunal ultimately decided that it was reasonable to let the Czech Republic cover part of its costs, although it conducted itself in the most professional and ethical way, and then essentially split the baby again and said the claimant must bear half of the costs. Now, in that circumstance, the Czech Republic had this ultimate question. Do we pursue this financially insolvent, in a colloquial way, claimant in Germany, and what are the implications of that, and how much would that actually cost the Czech Republic? And that's a real balancing issue. Or do we do that to send a strong message to all claimants that we're going to go after you no matter what? Now, in the recent case, we just got an award in September in the Feckling House versus Czech Republic case. Yeah, please jump in.
For a minute to add one more comment. Sorry for interruption.
Please.
Maybe one more piece of information to give you full picture. Claudia said claimant was not sophisticated. I agree with her. However, full claim or claim was for very significant amount of money. That's the point. Because if you face claim exceed billion Czech crown, you cannot say claimant is not sophisticated, we don't want to produce any reasonable defense for our interest. So the very first point is, if you are facing claim exceed billion Czech crowns or more, you have no option anyway. And the second point is linked back to previous panel. Because before he withdrew his claim, he was definitely trying to attract investor for his claim. So my very last comment to this point is we had to produce very serious defense. We spent serious amount of money, not only to dismiss this claim, but also to prevent the sale of the claim, or to sign or to prevent any side financing or something like that, which is sometimes the case in BIT, even speaking about cases against the Czech Republic. So sorry for that.
No, that's okay. No, absolutely. Just hand me that glass of water. Yeah. Yes, it would really be a very dangerous position for any state to underestimate their claimant, given the size of the claims, as Radek just explained, and somehow not put on a strong defense. And the messaging that that can convey for future claimants is not one in which the state could afford to take that position. Now, Laurent Lévy from Switzerland was the chair of the Napolsky case, and he was also one of the arbitrators in the Feckling House arbitration. And John Beachy was the chair, and Mr. Klein from Prague was also one of the arbitrators. Now, in that case, it was also brought under the German-Czech bilateral investment treaty, and the question was whether this claimant who had developed using third-party money directly from a bank in Germany, a golf course in its early stages, and then ultimately that endeavor did not prove to be successful. The business went bankrupt, and the claimant wanted to blame the Czech Republic for his lack of success in the bankruptcy proceedings, his lack of success with regard to criminal proceedings, and lack of success with regard to a variety of other proceedings in the Czech Republic, and brought a slew of claims. Now, that arbitration was brought under the UNCITRAL rules, and the tribunal issued an award in September dismissing all of the claimant's claims and awarding the Czech Republic its attorney's fees and costs. But the reasoning in that decision is really useful for states as they're thinking about these issues. Now, under the UNCITRAL rules, and these are the old rules, Article 38 says it's incumbent on the tribunal to fix the costs of the arbitration. And Article 40, 1, says, in principle, costs of the arbitration are borne by the unsuccessful party, subject to the tribunal's discretion, taking into account the circumstances of the case. So, in essence, if the state is dealing with an arbitration under the UNCITRAL rules, then you have essentially the costs follow the event concept built into those rules, and that's very important to cite. In that case, the tribunal found that the Czech Republic had been entirely successful in its defense of the claimant's claims, and held that the claimant should bear the fees and costs. So now the Czech Republic is going to pursue the enforcement of the fees and costs award because the claimant has not made a payment. And if the state doesn't pay, then it's very public actions by claimant's lawyers to pursue these steps, and it's got to be a message that is sent in light of the amount that this is something to pursue. And that's really where the Czech Republic is heading. Now, there's another decision that came out in September, and I think it's worth talking about as well, which isn't a Czech Republic case, but it's the Libanenko versus Turkey arbitral decision that was brought under the ICSID rules, and that also awarded fees and costs. In that case, you had Michael Wong as an arbitrator, Henry Alvarez, and Sir Franklin Berman. And that case was brought under the ECT by a Cypriot company regarding the seizure of 2 Turkish utilities. And ultimately, after many years, the decision dealt with jurisdictional questions about whether there was any evidence that the claimant had actually owned shares in those particular utilities. The case involved extensive forensic evidence and extensive amount of witness testimony and years of proceedings. The claim was $10.1 billion against Turkey. So to Radek's point, the tribunal essentially had to acknowledge that it was incumbent on Turkey to do everything it could to try to defeat this case. Now, given the size, these fees may not be so shocking, but they're very high. So the claimant's fees that they sought in the case were, fees and costs were over $24 million. $18 million for fees, and the remainder for costs. Turkey's fees and costs exceeded $35 million. $25 million in fees and $10 million in costs. Now, the ICSID rules do not have the built-in costs follow the event concept. Article 61.2 of the ICSID Convention essentially says tribunals shall assess the expenses incurred by the parties and decide how and by whom those expenses and fees and costs shall be paid. And then 61.2 gives the tribunal power to award costs and fees and discretion to decide at what level to do so. So you don't have a built-in component there. So the tribunal said the amounts, it might go without saying, the amounts claimed by each party are very substantial indeed. You can tell those were written by an Englishman. Recognizing that there was a multiplicity of issues of both fact and law, and significant amount of technical forensic evidence deployed by each party. Also very good for PricewaterhouseCoopers or other experts. But the tribunal said, we are constrained to observe that the explanation of why the expenses incurred is not the same as a justification of their necessity. Again, the explanation of why the expenses were incurred is not the same as a justification for their necessity. So the tribunal is going behind the submission that we did incur these and looking at, well, was that absolutely necessary, but recognizing at the same time that it cannot do what national courts would otherwise do and really go behind each particular expense. It noted that national courts really do look at these issues, and while they're not adopting a national court approach, they are saying to the parties, just because you've submitted this fee summary and you actually incurred these expenses, the question is, were they actually necessary? So they looked at 4 factors, 4-factor test again. The importance and value of the claim, which in this case was $10 billion. The amount of factual and expert evidence, the conduct of the parties during the proceeding, and the circumstances in which the work was done. Was there multiple jurisdictions, translation, travel, etc.? And the tribunal adopted the principle that the costs follow the event because it serves the purpose of compensating the successful party, discouraging unmeritorious actions, and providing a disincentive to over-litigate. But there are limits, and ultimately the tribunal wanted to take into account those issues where Turkey was not specifically the prevailing party on a particular issue. And in that case, and they're unique to those cases, to that case itself, Turkey was alleged to have conducted covert surveillance of claimants' representatives and other sorts of things that the tribunal obviously found was not necessary, and as they said, yielded little or no evidence. So they essentially went through the exercise of restraint. And this is an interesting phrase to the concept that Radek is talking about, the state must defend itself vigorously, that while Turkey's wish to assemble a powerful battery of legal and other resources is well understood, given the magnitude of the claim, the tribunal is mindful that it's the largest claim for costs on the record, and there has to be some proportionality of the award in terms of thinking about legal fees and costs, and that ultimately Turkey cannot be reimbursed for every expense. And so the tribunal split the baby and ordered the claimant to pay Turkey $15 million plus cover all of the fees and expenses of the tribunal. So in terms of thinking about where we're heading and what should states be seeking, I would submit that it is in the state's interests to have standards by which we know how tribunals are going to assess fees and costs. And it is in the state's interest at this point to have an approach that the loser pays, that costs should follow the event in investment treaty arbitration, because the historic reasons for not applying this approach really do not apply at this point. Ultimately, it is a very heavy cost for the public budget, and this is something that state officials have to explain on a regular basis. It's something that is causing governments to want to disavow investment treaties, and whether that is the right approach is a subject for debate. But if there's something that can ameliorate that concern, it would really be having a better approach to fees and costs. And then ultimately, are there other things that should be done, such as security for costs or other things to really put the state in a better position? And that's what Katrina is going to address next.